Celebrity host Steve-O. Sit back each week while Steve-O educates you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O with today's expert in their field.
Hey, good afternoon, and welcome to another Ask the Experts. We do so many shows with experts. I think this show is going to be probably the number one topic because it's on criminal law, and I guess people are just attracted to criminal law, and we were lucky enough to find an attorney. His name is Antonio Valiente, and what I love about him is he doesn't talk over your head. I understand everything he's saying. And let me tell you something, when you need a lawyer, you want to be able to understand everything. So welcome. You're with us every month.
Yes, sir.
How you doing?
I'm good. How are you doing, Steve?
That long drive in from Miami, right?
What's that? No, not too bad. I was actually at the Broward office today. So,
oh, okay. So you practice in Dade, Broward, and Palm Beach County.
That's correct.
And listen, you never know, especially nowadays, you never know when you might get pulled over, and who knows what's going to happen.
That's right.
I mean, it's really, well, I think it is, and tell me if I'm wrong, police officers have to be a little bit more on guard now than ever before.
I guess we'd have to ask one, but if I were a police officer, I certainly would be a little more nervous these days.
Streets are a little rougher. I mean, look at the guy who was, an officer pulls up in a white unmarked van, and right there off of 95, and the guy ends up getting shot and killed.
Yeah. Yeah, no, I mean, you never know, and I think distrust of the police, at least, I don't know, I don't want to say nationwide, but at least in this area in South Florida, is at least higher than it's ever been since I've been practicing law. So
I want you to tell people something, because this drives me crazy. I see these police shootings. I'm not saying all of them. I see these police shootings, and it always seems like somebody's resisting. It's like, use a little common sense. If the police officer tells you to do a flip, you better do a flip.
Yeah. I mean,
am I wrong? I mean, what should you do when you're pulled over?
Yeah, well, I think every situation's a little bit different, which is why it's so hard to just say.
But you should never run.
Probably not a good idea to run.
Okay.
Probably not a good idea to run. Certainly going to make the officer think that you did something wrong.
Yes.
On the other hand, it'll probably keep you from getting shot by the police officer, right? I mean, unless you're running at him, that would be a bad idea too.
And I don't know if this is the laws in Florida. If you run away in a vehicle versus running away on the ground, in Texas, one's a felony. If you're in a vehicle, it's a felony if you run. If you're on ground and run, it's not a felony.
Well, I can't speak to Texas law, but in Florida, if you take off from a police officer in a vehicle, that's going to be a fleeing and eluding, which is just a separate offense than just resisting an officer without violence, which is if you're on the sidewalk and an officer walks up or pulls up to you and he's working at the time, and he has a lawful basis to temporarily detain you, and then you take off and just run away. That's going to be resisting an officer without violence. And a lot of people think it's resisting arrest. In Florida, the charge is actually resisting an officer with or without violence. With violence would be a felony. Without violence is a misdemeanor. But it's not just why you're getting arrested. I mean, it's if a police officer exercising in the exercise of his lawful duties gives you a command, tells you, hey, stop or stay there, let me ask you some questions, and you turn and run away, that's going to, even though he may have not arrested you, he had no basis to arrest you,
right?
But he was allowed to ask you some questions, that could result in a charge of resisting an officer without violence.
And we have a main topic today, but I just want to throw a few questions in. Did you tell me last time that they have to advertise when they set up a checkpoint?
For DUIs?
For DUI?
DUI checkpoints need to be advertised ahead of time.
Tell you ahead of time. And where would you find that at?
You could find it in the local newspaper.
Okay.
Or the easier way that I would tell people is just there's apps you can get on your.
Oh, okay.
Yeah, you can get on your
But I
phone.
didn't know they have to advertise it that they're going to have a.
Seems kind of counterintuitive.
It does.
But yeah.
So anyway, we're going to talk about, boy, you hear still to this day, and I don't know, was it a couple of years ago, about Trayvon Martin and George Zimmerman, and there's so many people who have guns now. So we're going to talk today about stand your ground.
All right.
And, boy, there's so many. You know what? You can't read a person's mind. So this must be so hard for the courts. Though I did know a guy that he was going to gas station fighting over who got to the pump first, and a guy actually took gasoline out of his car and a lighter, and I guess was going to set this guy on fire, and he went to his car and got a bat, and he hit him. He didn't kill him, but he hit him, and he went to prison.
Right. Well, yeah. So stand your ground is something that obviously we hear a lot about. Trayvon
They said
Martin.
he didn't have to go to his car. He should have walked away.
Well, so in that particular scenario, that situation that you just described, unless the guy
How about
with
self-defense?
if the gentleman who was who was coming at him with the lighter and gasoline, let's say he followed him when he walked back to his car, I think certainly this person the person that went back to their car, would have been justified in whatever he did with the bat at that point. But the fact that he went back to his car, got a bat, and then, kind of re-engaged
Right.
the person with the match and the gasoline, that's kind of where the courts see a problem. Now, in Florida, you don't have a duty to retreat as in a lot of other places you do, where if there is a safe way basically to diffuse, to get away from this dangerous situation. In most other states, no matter how your scenario played out, the person who went to retrieve the bat would need to basically leave.
Okay.
And be followed and have absolutely no other choice. He tried to leave by going back to his car and get in his car and drive away.
That's what he should have done.
But he wasn't able to because this other guy followed him. So in most states, that would be okay if he then used his bat.
But
However,
to stand your ground, is that only with a gun?
So no. So in Florida, the stand your ground law, with the justifiable use of force or justifiable use of deadly force, it's with any type of force. It's deadly force as well as non-deadly force. So whether it's your fists or whether it's a knife, a baseball bat, or a gun, we hear about it. I guess the most common cases, the ones that you hear in the news, are usually with a gun.
Right.
And it usually ends up that the other person didn't have a gun or didn't have a weapon. But I guess that's what kind of differentiates Florida from other states, is that in Florida, you have no duty to retreat, not only in your home, but anywhere that you have a lawful right to be. So if you're somewhere that you're legally allowed to be, for example, you and I right now in this studio, right? I mean, we're not committing our presence here. We're not trespassing, so to speak. We're lawfully allowed to be here. If somebody were to walk in the door, approach us, and you have your back to the door, I can see this person, and I think that he is about to commit a forcible felony against you, or that he's going to place you or myself, in imminent fear of great bodily harm or death. I can use force, up to deadly force, to stop that threat, to stop him.
So if it's a carjacking and he doesn't have a gun, or he says he's got a gun and he's hiding it, you're carrying a gun, you are legally carrying a gun, do you shoot the guy? Can you shoot him?
Do you shoot him? I guess it's more of a philosophical question. Every individual needs to decide.
Do you wait for him to see if he's really got a gun? I mean, how
do you have to? No, you absolutely. You in Florida, you don't have to wait to see if he has a gun or not. I mean, even if he didn't say he had a gun, but the fact that he said, I mean, someone, let's say at a red light, you're by yourself in the car, it just opens the passenger door, gets in, tells you he's got a gun, and either get out of the car or drive. You don't need to wait to see a gun. You don't need to. He doesn't need to say he has a gun. The fact that he's committing a carjacking, and if you're in fear for your life at that point, and it's an objective standard, meaning what would a reasonable and prudent person in your position, would they be in fear that this person's going to commit serious bodily harm against them or kill them? If that reasonable person would think that, then you would be justified in using up to deadly force.
Have you ever had a stand your ground case?
I did.
Okay.
I've had several. I'd say the most notable was it arose out of a fight that took place outside of a Chili's in Miami Gardens in 2008. This actually happened. There was my client was with a friend of his right outside of this Chili's. My client had a firearm on him, and when there were some issues, there was an altercation inside of the restaurant. The other people that were involved left. My client, his friend, went out the front door, and before they left, they decided just to smoke a cigarette on the sidewalk in front of this Chili's. Again, not doing anything wrong. My client at this point had a firearm on him just because he always carried a firearm on him.
Miami Gardens is a little dangerous.
He was, everything is registered. Everything was on the up and up, and then
so he had a register. He was registered to carry a firearm.
He had a
concealed weapon. Okay.
His concealed weapons permit. Out of nowhere, and this is all on video actually, where you see him and his buddy smoking a cigarette, and kind of just into the picture comes this guy, walks up to his friend that's standing next to him on the sidewalk, and just out of nowhere just lands a haymaker to the side of his face, actually breaks his orbital bone on his eye. He goes down, his eyes bleeding profusely. At that point, the gentleman that punched my client's friend kind of starts putting his arms up and flailing them. The camera doesn't have audio, so you can't hear exactly what he's saying, but he was making threats towards my client. My client had taken a step back. At that point, a second attacker, the friend of the guy that punched my client's friend, walks up behind him. He comes into the screen, into the shot, and reaches for something. Looks like he's reaching for something under his shirt. As soon as my client sees that, he pulls out his firearm. He fires 5 times. They both, one of them falls there on the spot and is just kind of like, obviously in pain from being shot. The other one runs back to his vehicle, where he dies there on the scene. That one, the one that stayed there, the picture, he died at the hospital later. And my client stayed on the scene, but he basically waited for the police to show up. Once they got there, put his hands up. He was like, "Look, I'm the shooter." It was in self-defense. There was on that case, there was a stand your ground hearing, where if you're claiming self-defense, you have a hearing before trial, no jury.
Did they arrest him that night?
So they didn't arrest him that night. He cooperated with the police. He gave a statement, told them exactly what happened. I mean, he made his friends actually, and you see this all in the video. 3 of his friends, my client's friends, all get in their car and take off. And then you see my client, he just walks out of the picture. All of a sudden, his friends' cars that are taking off, you just see the tail lights, because it's at night. They stop, the brake lights, they stop, and they all of a sudden reverse, and all of them reverse back into their parking spots. And my client is on the roadway in the parking lot, actually walking in front of them. Basically, he stopped them and was like, you guys aren't going anywhere. You're staying here.
Right.
And you're talking to the police because you all saw what happened and know that, that we were attacked. So I'll abbreviate here because it's a case, happened in 2008, wasn't resolved till 2014. So
It took that long to resolve the case?
It did. So he was...
Why? Why would it take that long?
Well, he wasn't initially arrested. Miami-Dade homicide detectives did a 2-month-long investigation, and they ultimately determined that he was justified.
After 6 years?
No. This took them 2 months.
2 months.
They interviewed dozens of witnesses. They did their whole investigation and decided that he was justified in his use of force.
Okay.
Didn't arrest him at that point, and I'm not gonna. Well, I'll keep my opinion to myself as to why I think this happened. But at that point, Miami-Dade homicide was taken off of the case, and Miami-Dade cold case detectives were pulled into it. And
that means they take old cases and go back and...
Typically, cold case detectives, that's exactly what they do. I mean, there's a TV show about it. They take cases that were unsolved, 10, 15, 20 years later, and they dust off those old files, and they see, hey, let's redo this investigation now with a fresh set of eyes, with new technology. Maybe there's DNA that needs to be tested, or blood, or et cetera, things like that. So that's what cold case does.
That's scary.
Well, it would...
Because it should have been over.
Well, exactly. That's the point, right? It's kind of strange why detectives who typically handle 10, 15-year-old cases that were unsolved, why are they now investigating a case that homicide has determined wasn't a crime, and this isn't a cold case. This is, at that point, this was a 2-month-old case,
right?
Where it wasn't a cold case. You knew exactly who the shooter was. He was there when the police got there. He said, "It's me." He had all his witnesses. Cold case detectives.
Were his friends help to him as witnesses?
They were. I mean, a help, right? I mean, they didn't fudge their stories at all.
Okay.
I mean, they just said exactly what it was that happened. The cold case detectives redid the exact same investigation. They discovered no new evidence, but at the end of their investigation, they said, no, he wasn't justified, and they did arrest him.
Wow.
So,
that's scary.
Yeah. So after, a lot of preparation, there was... Did
they arrest him at that time?
At that point, he was arrested.
He was arrested?
Yeah. But there was...
And how long was he in jail till he went to court?
Well, I want to say he was in... It's a non-bondable offense, second-degree murder. However, you can get a bond on a non-bondable offense by having a hearing. It's called an Arthur hearing. His attorneys at the time, which it wasn't myself, his attorneys at the time handled this Arthur hearing and were able to, the judge set a bond, and he did bond out. So for the, all but, I want to say 4 to 5 months of, from 2008 to 2014, he was out of custody, thankfully. But we had a stand your ground hearing, and the judge at that point found that that he didn't think my client was justified in using deadly force. So the case was going to go to trial. At that point, we appealed the judge's decision. It went up to the 3rd District Court of Appeals, and they basically said the judge got it wrong. The judge applied the wrong standard. The trial court judge, in his order, said that he should have fired a warning shot, or he should have told them that he had a gun before using it, all of which the appellate court said, no, he has absolutely no obligation to do any of those things.
Right.
In fact, it's the opposite. A warning shot is actually a crime, right? Because the law says you're allowed to use deadly force if you believe that you're in fear of your life. So if you take out your gun when you're being attacked and you fire a warning shot, that kind of cuts against your argument that you're in fear for your life. Because if you're in fear for your life, you're not giving somebody a warning.
That's right.
Right. I mean, you're
not going to give them a chance to kill me.
Absolutely not. You're not going to, hey, please stop. Or you're not going to say to them as they're charging at you, sir, I have a gun. If you continue running at me, I'm going to be forced to, unholster my weapon and shoot you. Right. I mean, it doesn't work that way. So actually pulling out a gun and firing a warning shot, I mean, if that person that you've fired a warning shot at really, if they had balls, for lack of a better term,
yes, you can say it on here.
They could call the police, and you could be charged with aggravated assault with a firearm.
Wow.
Which is a 3rd-degree felony, and up until July 4th of 2016, carried a 3-year minimum mandatory prison sentence.
That's amazing.
Doesn't anymore.
I've got to ask this because I'm so nosy. That sounds really expensive.
Which part?
The part, his legal fees.
Oh, yeah.
How does a person be able to afford legal fees like that?
So I think most people probably can't, and he was no different. He had a private. When I said we didn't represent him at first for the Arthur hearing, he did have a private. He had hired an attorney who represented him from when he was arrested.
Appeals involved,
well, from when he was arrested until he was released from jail, he had a private attorney. When this all happened, I was at the public defender's office.
Okay.
So he wasn't able to afford an attorney, a private attorney at that point.
Right.
So he was appointed a public
but
defender.
appeals and everything.
Well, so that's when we got
expensive.
That's when I was assigned the case as a public defender.
Okay.
But yeah, no, it's expensive. I mean, I know the attorney from our office who handled the appeal had formerly worked at a large law firm doing civil appeals, and in her estimation, and now having my own practice, I can say that what she said is correct. He received, just from the public defender's office, probably the equivalent of about a $250,000
It sounds that way.
representation.
It sounds that
You
way.
know, I mean, it was a solid 5.5 years that he was represented. The amount of time and work that was put into his case, into his defense. I mean, some of the foremost experts in the country were actually called in to testify at his Stand Your Ground hearing. You know, an expert in gosh, it's escaping me now, but human factors, basically how people react under stress. To say
exactly.
You know, because in court it's very easy to take everything that happened in those literally seconds when he was outside on the sidewalk of Chili's with his buddy smoking a cigarette until that last shot was fired. We're talking a matter of less than 10
how
seconds.
Many people can afford $250,000? Maybe they might be able to afford 10 or 20, but when you get up and start appealing and experts are coming in, and how do people do that?
This case was probably extraordinary in that sense. You know, your average case isn't going to, even your average Stand Your Ground case probably isn't going to get you that high. I mean, this was a case that got, partly because it was not long after, you know, Florida enacted their Stand Your Ground, as well as in forgive me now if I'm off on the dates, but Trayvon Martin and George Zimmerman was around 2013.
I said 2 years. It's probably longer than that. It's got to be
It was
longer.
2012, 2013, I
Okay.
want to say, because this case ended up being resolved. The opinion by the 3rd District, which basically reversed the trial judge and said, or the Stand Your Ground, the judge that heard the Stand Your Ground hearing, and said that, you know, he applied the incorrect standard. He should have been, he should have been justified. He was justified in using force. And in Florida, when you're granted immunity, essentially, not just from criminal prosecution, but from civil liability as well.
Right.
Civil immunity. So somebody can't come after you. The family or the next of kin can't come after you and sue you in civil court either. I mean, they are actually, you're given immunity. Not only can the state not try to put you in prison, but the family, next of kin, heirs, etc., can't come after you in civil court and try to take all your money.
Wow, that's just amazing. So, God, you really have to think. If you have a gun license,
I think
you've got to kind of think before you do something. But maybe you don't have the time to, though.
Yeah, well, so yes and no, right? I mean, you do have to think, but at the same time, really, it's kind of I think most of the time that you see these cases, it really is kind of an instinctual thing. You know, people that carry firearms, I think I can probably speak for the 99% of them, which hope they absolutely never have to draw their firearm.
Right.
Because if they do, it means that they're in fear for their life and they're gonna shoot somebody and possibly kill somebody. And again, and this client of mine that I was just referring to, yes, ultimately he was given immunity from prosecution. All the charges were dismissed against him, and it was a happy ending, so to speak. But he killed 2 people.
Yeah.
I mean, he shot 2.
Exactly. That's on his mind for the rest of his life.
Right. And even though he was justified in doing it, even though, the court said he was justified, in his mind, he believes he knows that he's justified. And every time he sees his wife and his children, he's probably happy that he did that. But at the same time, I mean, we're not. Heck, I think even soldiers probably.
Oh, absolutely.
When you start killing people. I mean, it's not. You can't dehumanize that, right? I mean, it's gonna.
I remember I used to say when they had the draft, I went, "Gosh, if I get drafted, can I actually kill somebody?"
Yeah.
I mean, I don't know if that's the best way because it's either them or you.
Yeah. No, exactly. So you have to do it, but it doesn't make it any easier, so to speak.
Give
Afterwards,
everybody your phone number. We've gone through the whole show already. Give everybody your phone number and your website address.
So the website is, and all the information's on there. It's 786. Website is valientelaw.com.
So we better spell that too.
It's V as in Victor, ALIENTELAW.com, and our phone number is 786-361-6887, and for our Fort Lauderdale and West Palm Beach office, we have a different phone number. Well, I mean, ultimately, you can call either one. They'll all get to the right place. But in Fort Lauderdale, West Palm, the office number is 954-634-2764.
And we didn't even get to ask. God, this show just flew because one of the people asked, I want to get this in really fast because I actually promised him. He said, is it against the law to read your cell phone while you're driving?
To just read your cell phone is not illegal. It's not a crime. However, does that mean that if you're reading your cell phone, you're not going to get stopped or get a ticket for texting and driving? Not necessarily.
So there is one for texting and driving.
It's county by county for the most part,
okay.
And you can't.
Renee and I have a morning show,
right.
And when we go down 95 in the morning, you can see these cars all over the road, and 9 times out of 10, when we go past them, they're looking at their cell phone, doing something on their cell phone.
I drove home from Georgia yesterday, and it's not just on 95. But to answer the question, it's very difficult for a police officer or someone that's going to give you a ticket for this to know, are you plugging in your GPS information or are you text messaging when you're on your phone?
Right.
So is it illegal to put in your GPS coordinates? No, it's not. It is, you're not supposed to text and drive, but...
Well, write this number down because, look, you never know when you're going to need an attorney. 786-361-6887. That's 786-361-6887. Antonio Valiente. He'll be back with us again next month, and when we come back, we have our wellness show. We'll be right back.
Thanks, Steve.
Attorney Antonio Valiente has been chosen as the expert in criminal law by the Ask the Experts radio show. He has extensive experience successfully trying cases ranging from traffic misdemeanors to first-degree murder. Attorney Valiente has successfully argued motions to suppress, stand your ground, motions for new trials, and for judgment of acquittal, and defended clients in pretrial detention and probation violation hearings. Making sure you are represented by the most experienced and competent attorney in your criminal case you may have is essential. Attorney Antonio Valiente emphasizes to all his clients that while he is their attorney, he will guide them through the entire legal process and work together as a team. It is very important that your attorney is available to you to answer any questions you have. Attorney Antonio Valiente handles DUI cases, drug crimes, theft crimes, sex crimes, juvenile crimes, violent crimes, and gun weapons related crimes. If you get arrested, you need Attorney Valiente on your side. You can contact him at 786-361-6887. That's 786-361-6887. Or go to Attorney Antonio Valiente at valientelaw.com. Attorney Valiente practices in Palm Beach County, Broward County, and Dade County. The Anti-Aging Wellness Clinic is the leading international